on the point of negotiated settlements, am I to understand it, and for the benefit of a lay audience, that when a violation is found, the company can settle by paying a penalty that may be sort of determined through due process?
That is correct. And that is very, very important, because today the way the process works, Siddharth, is suppose the Competition Commission of India finds that you're abusing your market power. They can pass an order against you and restrain you from those kinds of anti-competitive practices. But the company can then appeal it to the NCLAT, which is the appellate tribunal. And again, from there on, they can also appeal it to the Supreme Court. That is their right. And that whole process can take 5 years, 10 years. As a result, the people that are getting hurt because of these anti-competitive practices, whether they're companies or consumers, will take many, many years to get justice. You have to pay a small penalty, but beyond that, you can keep on appealing the process. So by having a negotiated settlement, you can get the company that is at fault to change its competitive behavior, to pay certain fines, and then close this out much, much more quickly than going through this long appeals process. So that is a very, very major step forward. And most of the important economies around the world, UK, US, European Union, all of them have this provision where you can have a negotiated settlement of these kinds of competitive abuses and these kinds of long proceedings.
Will the fines be just a rap on the knuckle, or can we expect headlines of the sort that we see overseas, $500 million, $750 million settlement amounts? What will it be like here?
The penalties can be quite substantial, that those can indeed be negotiated.
One of my points, Mr. Sinha, before I move on to the ease of doing business, is in your own experience as someone who's been in industry and now in public life, do fines really work when it comes to big, powerful corporations as a deterrent?
They can work. And for instance, in the EU now, the fines are very, very substantial, up to 10% of revenue and so on. So they are quite sizable. And of course, they have an impact on your market cap and on your shareholders, which can create a problem for management. So that's one part of it. But perhaps more importantly, when you get into a negotiated settlement or where an order is upheld through the appellate process by the Supreme Court, for instance, the restraints on your competitive behavior can be extremely substantial. And we have seen that in some of the orders. For example, famously, AT&T was broken up, right, as part of a settlement that was done. Similarly, there were restraints placed on Microsoft after the antitrust cases against them in the US. There have been restraints on behaviors that the European Union has brought in terms of the use of data, the use of certain other services for some of the big tech companies. So these restraints on behavior can be very, very important and influential. And that's really what management tends to be more concerned about in some cases than the actual penalties themselves.
Well, this is an important point, viewers. Take note of what Mr. Jayant Sinha is saying. And this comes at a time when Meta has agreed to a settlement on the data leak that is famously called the Cambridge Analytica case for upwards of $750 million.
If you like the video, do like, comment, share and subscribe.